can actually stack those possibly. So you potentially could be looking at up to 25 years in prison.
Before we even press play on today's courtroom footage, let me set the stage, because what you're about to witness isn't just another sovereign citizen meltdown. This case answers a question that rarely gets explored. What happens when sovereign citizen arguments collide with an actual, flesh and blood victim? Not a traffic stop. Not a paperwork technicality. But a real financial loss, a real employer, and real criminal exposure. Brian Musgrove walks into Judge Anzaloni's courtroom believing the same recycled internet theories will save him, the all-caps name, the living man argument, the claim that courts are private corporations. But this time, the stakes are very different. We're talking felony embezzlement, tens of thousands of dollars, and sentencing exposure that could stretch into decades. Judge Anzaloni isn't known for entertaining fantasy law, and she makes that crystal clear from the jump. What starts as a routine pretrial quickly becomes a masterclass in how fast these theories collapse when facts, victims, and statutes enter the room. Pay close attention, not just to what the judge says, but how methodically she dismantles every claim. Because by the end of this hearing, the courtroom reality hits hard. Sovereign citizen logic doesn't just fail, it actively makes things worse.
Mr. Musgrove, you want to come up to the podium, please. This is in the matter of the people of the state of Michigan versus Brian Joseph Musgrove, file number 23-21461FH. I have Isaac Sneed appearing on behalf of the people, and I have Michael Dagger-Margosian appearing on behalf of Mr. Musgrove. Mr. Dagger-Margosian might. Oh, there he is. So, Mr. Dagger-Margosian, this is a date and time set for pretrial in this matter. Mr. Musgrove said that he was appearing on his own behalf. I did verify he is not an attorney, and you are still the attorney of record. So, Mr. Dagger-Margosian, how do you wish to proceed?
Well, Your Honor, I am aware that Mr. Musgrove wants to present information to the court. I'm happy to be standby counsel if he wants to represent himself. Obviously, this court would have to go through the colloquy of that, but obviously it's Mr. Musgrove's legal right to at least ask the court to do that. So I'm here to observe at this point.
All right. So, Mr. Musgrove, when you were at the bench or up at the podium before, you said that you were appearing on behalf of yourself. So, Mr. Musgrove, are you asking to no longer have counsel represent you?
Well, what I'm understanding is that the courts is a private for-profit.
So, Mr. Musgrove, I know where you're going with this, and none of that is valid. None of that is law.
I'm not the all caps name. Of course,
none of that is valid. None of that is law. You are standing in my courtroom. I have jurisdiction over you.
This moment right here is where the fantasy dies. The defendant tries to open the door to the familiar sovereign citizen script, private courts, all caps names, lack of jurisdiction, but Judge Anzaloni shuts it down instantly. Notice how there's no hesitation, no curiosity, no invitation to explain further. That's because these arguments have been litigated, rejected, and buried for decades. Courts don't debate internet theories. Jurisdiction isn't a feeling, it's established by law, geography, and the nature of the charges. When the judge says, "You are standing in my courtroom, I have jurisdiction over you," that's not rhetoric, it's a legal fact. And the frustration you hear from sovereign defendants often comes from realizing their script doesn't even slow the process down. This isn't bias or impatience, it's experience. Judges like Anzaloni have seen these arguments hundreds of times, and they know exactly where they lead. If you're watching and wondering whether these theories ever work, this reaction tells you everything you need to know.
So,
I tried to file paperwork with the clerk's office ahead of time so that you would have time to review it, and they denied me.
I know what you're talking about. None of that is valid under the law of the state of Michigan or the Constitution of the United States of America.
What do you mean it is?
No.
The Supreme Court says it is.
What does it say it is?
The Supreme Court says that if we were at the age of 18, we were supposed to claim our minor status.
Nope, not valid.
Okay.
So here's what I would say to you. Mr. Dagger-Margosian is, like most of our public defenders, exceptional attorneys and very well versed in the law and very experienced. He gives legal advice. You may not like the legal advice, but it's usually good advice. I've never had anyone from the public defender's office not wholeheartedly try to represent their clients. So what you are talking about is not valid, and it is not going to get you out of this case. You're not going to be able to say all those things because it's not valid.
Everyone involved in this court case has a financial interest in the case. It's what is.
I don't have a financial interest in your case. I get paid by the state of Michigan, whether you plead, whether it gets dismissed. I don't make any money off you.
Magic words fail. Invoke the Supreme Court. The problem? Sovereign citizens almost never cite real cases, just vague claims about what the court supposedly said. Judge Anzalone immediately demands specifics, because law doesn't operate on vibes or YouTube summaries. If a Supreme Court ruling existed that voided adulthood or criminal responsibility based on minor status, the entire justice system would collapse overnight. What's important here is how calmly the judge responds. She doesn't mock him, she corrects him. That's professionalism. And notice the deeper issue. The defendant believes secret legal loopholes exist that lawyers and judges somehow ignore. In reality, the opposite is true. If something were legally valid, defense attorneys would be using it every day. This exchange highlights the danger of misinformation, because instead of helping, it isolates defendants from legitimate legal strategies that could actually protect them.
We have budgets. The court system is not a profit-generating revenue. We are here to represent people so that people who are charged with crimes are protected, people who are victims of crimes are protected, and that's why we have all
But in
these.
order for there to be a crime, there has to be a victim. There is no.
Well, there is a victim in this case
The victim
because
would be the company. and the
you are
company-
charged.
I can't face. the
Actually,
company.
just hold on. So your crime that you are charged with, which you are innocent as of this time, let me grab the right file, is failure. Oh, this is let me see. This is an embezzlement charge. So you are charged in count one with embezzlement 50,000 or more, but less than 100,000. That being an agent, servant, or employee of Hardwoods of Michigan Industries did convert to your own use without the consent of your employer or principal, industrial tools and equipment in the amount of $68,938.40 or money or equipment. And that's a 15-year felony. So if you are found guilty by a jury, you can go to prison for up to 15 years.
This accusation, that everyone in the courtroom has a financial stake in the outcome, is one of the most persistent sovereign myths, and Judge Anzalone dismantles it point by point. Courts aren't commission-based. Judges don't get bonuses for convictions. Prosecutors don't profit from longer sentences. The irony, as the judge subtly points out, is that the only person financially impacted long-term is the defendant. Prison destroys earning potential, stability, and future opportunity. This moment reframes the narrative completely. The court system exists to balance rights, protecting defendants while also protecting victims. That balance collapses if we pretend crimes don't require accountability. And this case isn't theoretical. Money went missing. A business was harmed. The victim isn't abstract. When courts emphasize victims, it's not emotional manipulation, it's legal necessity.
You're charged in count two with using a computer to commit a crime. To facilitate the charge in count one, that carries a maximum penalty of up to 10 years in prison. And the way the statute's set up, I can actually stack those possibly. So you potentially could be looking at up to 25 years in prison. So the victim that's alleged in this would be that business.
Right, and I can't face that accuser because that business can't get on the stand for me to ask questions, and a third party.
But their
can't stand
representative
it.
can. Yes, they can.
They
Yes, they
can?
can. Yes, they
Okay.
can.
This is the turning point of the hearing. Up until now, the defendant treats this like a philosophical debate. Judge Anzalone brings it crashing back to reality with numbers, statutes, and consequences. Embezzlement of $50,000 to $100,000 is not a paperwork issue, it's a 15-year felony. Add the computer use charge, and suddenly we're discussing stacked sentencing that could reach 25 years. That's not fear-mongering, that's statutory law. The judge's tone is deliberate here, she's not threatening him, she's informing him. And that distinction matters. This is the court giving a defendant every opportunity to understand what's at risk. Sovereign citizen arguments collapse fastest when real sentencing exposure enters the conversation, because ideology doesn't protect you from prison time. Facts do, or don't.
So I have $189,000 of student loan debt that was forgiven to be a lawyer. You do not. and Mr. Dagger Margosian, Mr. Isaac Sneed, all of the attorneys here went to law school to know the law, and their job is to advise you of the law. So
Yeah,
yes, they
they're-
can. Yes,
They're
you
going
can be
by
charged.
everything, all the
can't-
laws and statutes that you guys go by
Are
for
legal.
corporations. They're for fictitious.
Still a crime. Still a crime.
But I'm not
Still a
fictitious
crime.
corporation, I'm a living person.
Yep, and that's why you're standing in front of me. If you were dead, the case would be dismissed.
Yeah, the all caps name is that.
That means nothing. That's not valid.
Okay.
It's not legal.
right.
So, do you want to represent yourself, or do you want to have an attorney to represent you?
I need some time to think.
Okay, so I'm gonna set this for another pretrial on March 20th at 8:30 in the morning. And Miss Adams, could I get a notice of hearing for Mr. Musgrove?
This argument sounds clever until you understand basic legal structure. Corporations are treated as legal persons, but they still act through human representatives. That's why witnesses testify, records are introduced, and attorneys speak on behalf of entities. Judge Anzalone is absolutely correct, and this is standard across civil and criminal law. What's fascinating is how often sovereign citizens accidentally admit they understand this concept when it benefits them, yet reject it when it doesn't. Courts don't reinvent procedure for individual defendants. The rules exist to ensure fairness and consistency. This exchange isn't about denying confrontation, it's about applying the law correctly. And once again, the defendant's misunderstanding only weakens his position.